many of the associates here, have a broad practice that spans corporate commercial work, administrative and regulatory, as well as I do some criminal defense work. I was co-counsel with Gerald in that matter pertaining to a dispensary in Toronto that was facing being shut down as a result of contravening local bylaws. We raised some novel charter arguments to say that absence of storefront access of medicinal marijuana was a violation of Section 7. Unfortunately, that was not accepted, but it was fun making the argument. And I've had an interest, really an academic interest, in the developing cannabis world for a number of years, because I think it's fascinating. And this has probably come out in my presentation, that we have really an entire new industry that has been thrust upon us in sort of 3 years' time. So that's my presentation, is a short history of cannabis retail, and I'll be focusing on Ontario. And I really think one of the takeaways that I'd like to have here is that we've seen a lot of developments in a very short period of time. And that means that we know a lot more now than we did in 2015, but there are still a lot of questions that remain to be answered. We theoretically have a retail regime here in Ontario, but don't actually have any brick and mortar stores. So there's a long way to go. So legalize it. That was the plan. Trudeau government, or the Trudeau Liberal Party, ran on a platform involving the legalization of cannabis in 2015, and sure enough, was swept into power in a majority August 19th, 2015, so just over 3 years ago. And it quickly became apparent that the Liberals would make good on their campaign promise to legalize cannabis. Having said that, the clock was ticking right away if this was going to get done within the election cycle. So it's really been short work. As early as the spring of 2016, if not earlier, we began to see, certainly here in Toronto, a number of unlicensed illegal dispensary storefronts pop up, with a lot of operators seeing if they could get a head start in capturing a market share by having a retail space right away. Certainly worth the risk. And there were mixed messages from law enforcement and the government as to whether that would be tolerated. Certainly these dispensaries were acting out in the open, and there was a bit of a variety of enforcement as you went across the country. In November 2016, the McClellan report, the framework for the legalization and regulation of cannabis in Canada, came out, and that was the first word, at least the first public word, as to where the federal government, was looking in terms of a regulatory structure. Importantly for this presentation, it indicated that provinces and territories would be responsible for regulation of the wholesale distribution of cannabis, and that provinces and territories, it recommended that they, in close collaboration with municipalities, would be responsible for the regulation of the retail sector. The next watermark was April 2017, Bill C-35, which would eventually become one of the acts named the Cannabis Act, the federal version, was tabled, and that established a national framework for the governance and regulation of recreational cannabis in Canada. And it indicated that provinces and territories indeed would be responsible for regulating the distribution and sale of cannabis within their jurisdictions. Around the same time, remember this is April 2017, the federal government came out and said that cannabis would be legal July 1st, 2018. So starter's pistol went off, and 15 months to get a regulatory regime in place virtually from scratch. Now, we know the Cannabis Act ultimately received royal assent June 21st of this year, and that July 1st target date was pushed back to last week, October 17th. So the provinces get to decide what their retail regimes are going to look like. And this is a bit of a foreshadow of the fact that Ontario had a last-minute flip-flop, as we all know, because Ontario is still the light green representing public retail sector. So throughout the country, there are various different approaches that have been taken. Saskatchewan and Manitoba are the two jurisdictions that have elected to have entirely private retail sales, both in person and online. Alberta, Newfoundland, Ontario, and the Northwest Territories all have privately run retail stores. In Northwest Territories, it's actually just liquor stores can apply for a license to sell cannabis, but government-operated online sales. BC has one of the most interesting regimes because it's a mishmash of everything. They have a full private and public sector retail regime, both online and in person. New Brunswick, Nova Scotia, PEI, Quebec, and Yukon all have wholly government-run regimes. And then finally, Nunavut has invited established online vendors in other jurisdictions to sell in that territory, but private licenses for stores will not happen until after 2018 because of a public consultation process. So that's just a snapshot of how things are looking province by province. So in Ontario, we thought we were going to go public. Public sector model, that was the plan. In September 2017, the Wynne government announced, so this is, again, April was the first indication that the provinces would be responsible for regulating retail. In September, the Wynne government comes out and says, we're going to regulate cannabis using an LCBO model. And that means two different things. It wasn't called the Ontario Cannabis Store at that time, but the Ontario Cannabis Store which is a subsidiary of the LCBO, would be fully responsible for wholesale distribution, but also for all retail sales, so essentially mirroring the LCBO model. There are positive and negative aspects to this. I'm of the view that given the tight time frame, it made a lot of sense to have to build a retail sector on an existing framework of stores and supply chains. Now, one aspect of the Wynne plan was that there would be no co-location, meaning you couldn't open up these OCS stores within boutiques in existing LCBO stores, so all new leases. But my view is that given the short amount of time to get to market, it made sense to map onto the existing framework. There are downsides, the absence of private sector. Well, first of all, to a certain degree, the LCBO model, in general, is a little bit outdated, and reasonable people can disagree as to whether it should be in place at all. But also, in absence of differentiated private stores, you have less sophisticated store owners and less choice in terms of products and various strains and whatnot. So under the Wynne plan, there were to be 40 stores opened by initially July 1st, later October 17th, 80 stores by 2019, and 150 by 2020. So that was the plan, and then things changed. Never forget that. Throw that out. There was an election in June, and we have a new premier as a result. And despite the fact that this wasn't really an explicit campaign issue, in July of this year, just a few months, really I think 80 days or so before the October deadline, we started to hear grumblings that the provincial Conservatives were rethinking the OCS model. And just as a reminder, Ontario, after California, would be the second largest cannabis market in the world. So pretty important implications to the decision here. So in July, well, I guess it was August, some Kate's guy wrote an op-ed suggesting that Ontario follows suit with the BC model. What BC was doing is having, as I mentioned, a dual track. On the one hand, you've got a public retail model that would ensure that, first of all, there's a possibility that private sector might not go to certain areas of the province. And so a public model would ensure that there would be stores appropriately spaced throughout the province. having said that, as I said earlier, very challenging to put in place a private system with the short amount of lead time that's out there. And so they didn't listen to me. Go figure. 5 days after this was published, the Ford government announced that they were just going to ignore the October 17th deadline altogether. Online sales were going to be still with the OCS, but there would be a private sector regime put in place by April 1st, 2019. And so in my remaining time, I'm going to walk through some of the features of the Cannabis License Act 2018, which was tabled September 27th, not yet in force. It draws on the Liquor License Act, Gaming Control Act, and Horse Racing Act, License Act, as well as legislation in other jurisdictions. So it's sort of on the one hand, it lends itself aspects from all different kinds of legislation in place, but it's very much a unique Made in Ontario model. And kudos to the drafters, because as I said, the announcement was August 13th, and this thing was tabled September 27th. That's a crazy turnaround time. One overriding feature is that for each retail location, you need both a license and a store authorization. And the other important thing is that the devil is very much going to be in the details, which are regulations that have not yet been drafted. So what are some licensing policy issues? And if anyone gets my license to ill reference, then congratulations. But so the things that I want to go through quickly are market concentration, what to do with existing gray market operators, and to what extent will there be local input. And I think these are areas where there was play in terms of policy choice, and we see different things that will be done across the country. In terms of market concentration, the question is whether anything will be done to spur competition, and in particular to avoid monopolies. What we've seen in Alberta is that there is a cap on any company or group of companies under common control from obtaining 15% of the total number of licenses issued in that province. In BC, any single company or group of companies is limited to 8 licenses in an absolute sense. What Ontario decided to do was not to put any sort of absolute cap, first of all, in the overall number of licenses, and some government sources have indicated there could be between 500 and 1,000 stores in short order. Now compare that to the Wynne government's plan, which was to have 40 stores by this time, and 100 stores, 150 stores by 2020. So much more breadth of locations with what's been put in place. The most interesting development is that the licensing regime limits licensed producers and their affiliates to one retail store, and that has to be on the site of their that is associated with their production license. So it's akin to having a boutique store at a brewery, and that is significant because in other provinces, in particularly Alberta, the LPs have been lining up to corner the market in the retail space because, as Lindsay was saying in her presentation, there's huge limits in terms of marketing opportunities. And so to have control of a retail space allows you to play with your branding opportunities. And so all of the share prices of all of the big LPs all dropped the day that these licenses, this licensing regime was announced. Now, devil is in the details, because what it says is licensed producers and their affiliates are limited to one retail store. Well, what does an affiliate mean? They're drafting it. We don't know yet. And so that is a question that is out there as to what extent LPs are still going to be able to widely have storefronts. Another thing I just wanted to mention is there may be other things that make it difficult for non-corporate, the grassroots owners to break into the market. For instance, in terms of the regulatory and reporting obligations, there is seed tracking obligations. They're very sophisticated regulatory requirements that may be difficult to see something like a mom and pop shop open up. In terms of the gray market operators, I'm speeding because I'm running out of time and I don't want to make Andrea any more upset than she is with me. So big question is whether those people who set up to get a jump on the market were going to be rewarded for operating illegally beforehand. And two different approaches in BC and Alberta. Alberta, if you operated an illegal storefront, you were barred from applying for a license. In BC, you could maintain continuity with your storefront and open right up. We've taken sort of a middle of the road approach here in Ontario. If you shut down your dispensary on October 16th, you're fine. You can apply for a license, but you're not going to be able to operate continuously until April 1st. It's not explicit, but the way the regime operates, there's a high risk that you'll be ineligible from ever applying for a license if you continue to operate an illegal dispensary. A few reasons we say that is, first, that you are prevented from applying if there is reasonable and probable grounds that you will not carry out the business in accordance with the law or with integrity, honesty, or in the public interest, having regard to past and present conduct. Secondly, if the applicant or persons interested in the applicant, and that is very broadly worded, or its directors, officers, or shareholders have been charged or convicted with any offenses that Gerald set out, basically. So if you get caught, and there are raids going on right now to try and shut down the retail stores, if you get caught up in that, you are barred from ever applying for a license. And then finally, any circumstance that may be prescribed. I'm out of time. The last thing I did want to mention was the extent that there would be local input, and I will just say that municipalities have been left with very little say in this, which actually I find very surprising. Municipalities basically have one shot to opt out, and they have to decide by January 22nd. And if you opt back in after you've opted out, you're in. So it's an in or out decision that needs to be made, and there's no ability to specifically zone. You can't create a specific zone designation for cannabis retails like you can with liquor stores. So there's very little ability for municipalities to control what happens. Essentially, the provinces said we're going to cover the field on this. Different on reserves. Reserves have a bit more flexibility. So takeaways. Lot of progress in a short amount of time. But we have to take that with a grain of salt. In Ontario, given that we don't even actually have any stores here yet, we have to bear that in mind. There's a lot of there's a lot of risk and uncertainty for the key players in the markets, who are the big LPs and the existing dispensaries. And then finally, I do want to mention that the AGCO is the regulatory body that will be that will be enforcing the licensing regime, and it's on their website. They have a policy of employing a standards-based approach to regulation that is outcome-focused. So what that means is we can have some confidence that the regulator here is going to prioritize substance over form and not take an overly technical approach to enforcing the regulations whenever it is they get drafted. Thanks very much.